Good afternoon and welcome to our webinar on moving away from lockdown and towards the return to work. I'm Karen Plumley-Jones. I'm the practice development lawyer for the employment team at Womble Bond Dickinson, and I'm based at home in Wiltshire. I'm joined today by my colleagues James Wilders and Joe Martin. James is a partner in our Newcastle office and Joe is a managing associate in Bristol. Both of our speakers have been advising clients the employment law implications of COVID-19 over the last few months, as well as writing articles and speaking at various webinars. This webinar is very timely because, of course, the Chancellor announced some major changes to the coronavirus job retention scheme on Friday, and we're going to cover those today. In addition, you may have seen there was a recent survey carried out by People Management, which reported last week, and that found that over 40% of employers expect job losses when the furlough scheme ends. So we're going to look at planning for possible redundancies as well. So today we're going to cover 4 topics, and they are: how will the coronavirus job retention scheme work once it's extended from the 1st of August? What if an employee refuses to return to work because they're concerned about contracting the virus? Can employers impose short-time working or layoff pending a return to full productivity? And what steps should employers be taking now to prepare for possible redundancies in the future? James and Joe are going to talk about 2 of these issues each. We'll take questions at the end of each section and at the end of the webinar as well. So before we start, I have a couple of housekeeping points. We are recording this session, but we won't be referring to individual names or organisations when we answer questions, so everyone will remain anonymous. How to ask a question? The Q&A feature should be visible in your right-hand panel. To expand it, simply click on the arrow, and at the bottom of the screen you'll see a free text field where you can type a question. Once you've typed your question, you just need to press enter to submit it. If your Q&A panel isn't visible, then you need to click on the More Options button on the control panel, which has 3 white dots. Q&A will then be an option at the top, and you need to click once to re-enable it. Questions can be submitted throughout the webinar, and we will pick up some at the end. If you think of a burning question after we've finished the relevant topic, type it in anyway, and we'll try and pick it up at the end if we've got time. Finally, we're going to be using some polls during the session. Once the poll is opened, you'll receive an on-screen prompt to answer, so please do join in with those. So let's get on with the webinar. We're going to start with the changes to the coronavirus job retention scheme, which Joe is going to cover. Joe, over to you.
Thanks very much, Karen. Hello, everybody. Right, I'm going to dive straight in. So some stats to start with. We've got 8.7 million employees furloughed in this country at the moment. That's about a quarter of our workforce in the UK. 1.1 million employers are using the scheme. I imagine probably everyone on this call is representative of an employer organisation using the scheme. The claims made to date amount to £17.5 billion worth. As you're probably all aware, the scheme was extended. It was due to end in August. It's been extended to finish now on the 31st of October of this year. That was announced earlier this month. And as Karen mentioned, the details of that extension and some other information was announced last Friday. So the main thrust of the details announced on Friday are as follows, and I will go into more detail on each of these. You've got the closure of the scheme to new entrants, which I think is very important that we all understand how that's going to operate. That's from the 30th of June, and there's limitations on what you can do and how you can claim after that date, which I'll go through. There's then an element of flexibility that's being introduced, mainly being able to bring back employees part-time from furlough, but when they're not working for you, they partly remain on furlough. Idea, I'm presuming, is to aid with the reignition of businesses and the rebuilding of what businesses are going to do when the economy gets back on its feet. Then the last part of the information released on Friday was how the government are starting to taper, or will start to taper, their funding. for employee wages. So that's from the 1st of August. And again, I'll go through all of the dates and what's going to happen on that in a moment. Plan being to avoid a cliff edge. Absolute startling drop in funding. All of a sudden, they're describing that as a cliff edge that they want to avoid, hence the tapering, weaning employers from that sort of state assistance, if you will. You may have already had a look at the changes. Our view is that it will probably feel a bit of a steep drop. Maybe not a cliff edge. We'll go through the tapering elements, but it's going to be a bit of a steep drop still, unfortunately. All of this will undoubtedly bring the health of your individual organisations into sharp focus. And I'm sure that's already been uppermost in your minds for many months now. We'll go through the details now, and later on, as well as the other elements we're looking at. Sadly, we're also going to be looking at redundancies. We will all already have been, I'm sure, and James will be going through in more detail what to be ready for, how to address that as well. So taking first the closure of the scheme and a headcount limit that's coming in. So from the 30th of June, scheme closes to new entrants. That means after the 30th of June, you can have no new furloughing agreements, by which I mean the letter or document that you agreed furlough with an individual. You can't do that for the first time with an employee. Where the employee has previously been furloughed for at least 3 weeks, as you probably know, you have a 3-week minimum furlough period for it to be valid furloughing. Where you have already furloughed an employee before the 30th of June, you can furlough them again after the 30th of June. So what this means is you need to have a think about who you might want to furlough before the 31st of October 2020 when furloughing ends. If you might want to furlough someone between now and 31st of October, make sure they have been furloughed for 3 weeks before the 30th of June. That lends itself to a sort of last chance saloon type period of time, which is the 10th of June to the 30th of June. You've probably already worked this out, but just to make it absolutely plain, the last chance to qualify an employee will be starting furlough on the 10th of June for 3 weeks in order that they have been furloughed before the cutoff. So some point between the 10th and the 30th, you need to be furloughing that employee, then they're valid for the later period. You don't have to, but if you might want to furlough them later, that's your last chance to do it. Slightly unhelpfully, the further guidance on all of this is being published on the 12th of June. So deep breaths all round, and I'm sure there's been plenty of deep breaths for many months now for various reasons. We will know more on the 12th of June. Yes, it's before the 30th, that's helpful, but you will have actually needed to have started furloughing your last chance saloon people by then. Something else to bear in mind is that in any claim period after the 30th of June, you can't claim for more heads of employees than you did in a claim period prior to the 30th of June. So an actual consideration of headcount is important as well. How many have I furloughed to date? Am I likely to want to furlough more after the 30th of June by headcount? And if so, the claim period or the period for which you claim before the 30th needs to have at least that many heads in it for you to be allowed to claim that many after the 30th of June. The administration of claims after the 1st of July will be required to be by month. Currently, apparently you can mix, I say apparently, I'm not on payroll and HR actually functioning these submissions to HMRC, but you can allow periods to overlap. That won't be allowed after the 30th of June. It will be month, month, month. And reason being, as we'll see, the tapering changes month by month when the tapering starts. So they need to have that, the HMRC need to have that very clearly claimed by month. So in terms of the flexibility that was announced last Friday, this is relatively straightforward in as much as from the 1st of July onwards, you can bring furloughed employees back part-time. You will be responsible 100% for the employee costs for the time they work for you. The government will be responsible for the time they aren't working for you, subject to the cap prorated to the time they're not working for you. Any such arrangement, clearly with shift working, could get relatively complex. HMRC want that claimed in blocks of a week. So when you're planning a part-time unfurloughing, make sure that the pattern will work in blocks of a week. And as we all, I'm sure, know and are confident about, that arrangement must be agreed in writing. So good practice in any event, but it will have to be set out in writing, as I'm sure you would prefer anyway. So as a first poll for everyone who's registered today, would you mind answering the question of who is planning to bring back any employees part-time? Obviously no right or wrong answer. We're just interested to see if people started thinking about this. Are they expecting it to be helpful? Do people have set plans? We've got a 60-second limit on that. So if you wouldn't mind finding the poll, it should be to the right of your screen, and letting us know what your organisation's plans are. As Karen said, it will be entirely anonymous, confidential. We'd be keen to know what the intentions are around this. So 30 seconds left. Okay, that's interesting. I think we can all see the outcome there. Hopefully you can also see that. So 72 out of 120 people who have commented will be bringing back part-time employees. 40 are saying no. Perhaps a not sure yet option would have also been fair, given there's a lot everybody's chewing over at the moment. Thank you for that. So looking now at tapering, which in some respects is the key bit of information here. So for June and July, it's the same as at the moment. Save the aspects around headcount and making sure you've got people you want to furlough in future, furlough before the 30th of June. Those elements you need to think about now. But in terms of government funding of salaries, June and July are as per the prior month. So that's the government paying up to 80% or £2,500 cap of salaries for the hours the employees aren't working. And they're phrasing it like that because there's a chance that some of these employees will from that then on be working part-time. So for the hours they don't work, that's the applicable cap. Government also paying employers' national insurance as currently, and auto-enrolment minimum pension contributions as currently. So no change till August. From the 1st of August onwards, the government will still pay up to the 80% £2,500 cap, but they're expecting what they describe as a modest contribution from employers, which is to pay the employers' national insurance contributions and the employers' auto-enrolment pension contributions. They've said they estimate for the average claim that's around 5% of the gross employment costs for that employee, just by way of giving some context to what they're asking for from employers in August. So I say from 1st of August onwards, actually that's for August. It changes again in September and then it changes again in October. So let's look at September. So from the 1st of September, for September, the government will pay up to 70% or £2,187.50 cap of salaries for hours employees don't work. Employers, as per August, pay employers' national insurance, employers' auto-enrolment pension contributions, and 10% of the wages up to the cap. So looking at it from the employee's perspective, nothing changes for them. And that's actually true all the way through to the end of this scheme. The employee receives the 80% £2,500 cap. What changes is whether it's employer or government who are paying how much. The government, again, for that context point, estimated that's around 14% of gross employment costs for that when the employee's working normally, what they would then cost. So for October, the final month of the scheme, and it's at this point when I was preparing for this talk, I thought, oh, okay, we're at October already. It does feel pretty swift, but there we are. From the 1st of October, the government contribution drops to 60%, and that's the £1,875 cap. The employer contribution is 20%, and the employer, as before, since August, is paying employer national insurance and employer auto-enrolment pension contributions. Employee experience remains the same, 80%, £2,500 cap in total from the dual contributions now by employer and government. On that context point, that's around 23% of, or averaged 23% of gross employment costs for that employee normally. So then we're on the 1st of November, furlough scheme is closed, finished. Employers are going from that average of around 23% of their gross employment costs to 100% from the 1st of November. Bit of a steep drop, as I said, I think it's fair to say. The Treasury has analysed the total cost if you had furloughed someone from beginning to end of the scheme, and I know it's not the same for every organisation, but for the sake of example, the average employer apparently will end up spending around 5% of normal employee gross costs over that time, depending obviously on employee wages and what have you. So that's the tapering element of the changes. Now, briefly, as I think holiday's not been the easiest part of the furlough scheme to grapple with, not least because of some really aged case law and very academic points coming up on various elements of it. But I'm just going to do a quick run through of what we know about the holiday position, and then we can see what questions might have come in on the furlough scheme. But just touching on holiday briefly. So as I think we all know, employees continue to accrue statutory holiday during furlough, plus any contractual holiday they're entitled to. Employees can take holiday during furlough. Employers can require, sort of politely demand, that employees take holiday or don't take holiday. They have to give a notice, a set amount of notice, which is twice the amount of the holiday they are demanding is taken or is cancelled. Holidays paid at the employee's usual rate. And again, as I think we're all fairly familiar with, but still chewing over to a degree, where it's not reasonably practicable due to the effects of the coronavirus for the employee to take holiday, it can be carried over for up to 2 years. Query, will that always be made out on the facts? It's worth considering it on a case-by-case basis. It may well be entirely possible for the employee to take leave during furlough. There's some guidance around if it's not going to have the health and safety benefit that it should have. Again, case-by-case assessment, I think, is wise there. So that's just a quick run through of the holiday. Now, Karen, do you have any questions that have come in, or please feel free to type in a question if you haven't had the chance yet on anything we've covered there?
Yes, I do, Jo. The questions are flying in, and a lot of them are around what happens after the 30th of June and this requirement to have furloughed somebody before then. So I'll take a couple of those. We've also had a question on holiday, so we'll cover that one as well. So in relation to furloughing somebody for the first time before the 30th of June, one of the questions is that we've been moving employees on and off furlough on a rota basis. Can we put someone back on furlough on the 30th of June as long as they've been furloughed already at some point, or do they have to have been on furlough from the 10th to the 30th of June?
Brilliant question, thank you. The short answer is no, you don't have to sort of whack in an extra bit of furlough between the 10th and the 30th of June. If they've had a valid furlough period at any point since the scheme started, and by valid that means a minimum of 3 weeks, then they will be furloughable after the 30th of June, is our understanding. It's a bit of a lawyer's caveat there. We've got more details coming on the 12th of June, but I think it's fairly clear from what we've been told already that that's the situation.
Thank you, Jo. And another question on the same point, really. Can we furlough and unfurlough employees after the 1st of July? And if so, does the 3-week minimum still apply?
Yes, you can unfurlough and refurlough from 1st of July onwards. Obviously, to furlough, they need to have been furloughed prior to the 30th for at least 3 weeks to be validly furloughable after the 30th. The 3-week minimum, I'd be very surprised if it didn't still apply. I don't think they explicitly touch on that in what's come out on Friday, but there's certainly no mention that that's no longer required. And I think for the sake of certainty, I'd be very surprised if they did away with that 3-week minimum. I'm not expecting that.
Okay, thank you. And another question on the same topic. Can we furlough staff from the 10th to the 30th of June and then have them come back part-time?
Yes. Yep. There's nothing special about that period of time, save that it's the last chance saloon for someone who's never been furloughed before to make them furloughable after the 30th of June. And any employees on furlough from the 1st of July onwards can be brought back part-time.
Okay, thank you. And then a question in relation to reporting. So one of our delegates has asked whether employers are required to report the hours worked and the usual hours an employee would be expected to work in a claim period. Can the hours worked be flexible, or do they need to be set in stone in the agreement at the beginning of the furlough period?
I would imagine you'll need to report usual hours versus hours being worked on this flexible basis, because that will then enable HMRC to check the prorating of the contributions. In terms of flexibility around hours worked, I would imagine that's provided it's reported accurately and there's no breach of contract or breach of this sort of mini agreement for the part-time period between employer and employee, that it will be fine as long as it makes it into the claim clearly representing what was done by the employee when they came back part-time. So if it changes from the agreement, but that's fine with you and the employee, just make sure that's then shown in the claim made for their time working versus their time on furlough.
Thank you. And then finally, a question in relation to carrying forward holiday. Do employers have to let employees carry forward holiday into the next holiday year?
They will have to if the employee it wasn't reasonably practicable for the employee to take that leave due to something relating to the coronavirus. So I appreciate that sounds a bit woolly, but that's the law that was brought in to protect the leave where an employee wasn't able to take it for that reason and to allow it to be carried over for those years. So that will be a requirement on the employer, but the employee would need to show that they couldn't take it due to coronavirus, and that's going to be a factual analysis on a case-by-case basis.
Thank you very much. And let's move on to our second topic, and James is going to cover this one. So the second one is, what if an employee refuses to return to work because they're concerned about contracting the virus?
Thank you, Karen. Hello, everybody. Greetings from Newcastle, a slightly sunny Newcastle, not as nice as it has been. So yes, what if someone refuses to return to work because they're worried about catching the virus? Well, there's a couple of themes running through this topic, which I should first of all highlight. First of all, the importance of consulting with staff, with informing them, with having a dialogue with them. And secondly, the importance of record keeping. Record keeping in particular to show the thought process you've gone through and the dialogue that you've had, so that you're in a position subsequently to be able to explain the position you've adopted if you're ever challenged. So dialogue, stroke consulting, and record keeping are both crucial throughout all of this. In normal times, if somebody refuses to come back to work without a decent excuse, an employer would be fairly robust in their response. Maybe looking at withholding pay and or disciplinary action potentially if someone says they don't want to come to work. These, however, are not normal times, as we all know very well. And in these times, if someone is reluctant to come back to work, I would say first and foremost as an employer, you need to be sympathetic. Listen to what their concerns are, have a dialogue with them, and try and address those concerns. Listen to them and try and respond to them in a sympathetic way. Especially see if there's any alternatives that you can propose to the individual having to come back. Can they do their normal job from home? Can you adjust their duties so that they can do an adjusted role from home? Can they come back to work, but can they work in a designated space where they're separated out physically from colleagues and therefore have a reduced likelihood of potentially contracting the infection? Can you leave them on furlough leave? Can you put them on holiday? Or maybe try and agree a period of unpaid leave with them. There may be some problems associated with that in the context of an employee being subjected to a detriment for health and safety reasons, which I'll come on to, but that's a possibility. And also think about whether or not you actually need the specific individual, that particular individual, back at work. Does that person need to be at work? Are there others who could be at work in their place? So think carefully about the basis on which you select people to come back to work. So there may be ways and means around addressing the problem if someone says they don't want to come back to work because they're worried about contracting the virus. The important thing is to engage with the individual, engage with their representatives, especially if you have a recognised union. Discuss the safety measures that you've put in place. If you've worked hard to make sure that there is a safe working environment, you've had deep cleaning, you've adjusted the people's workstations, whatever it is you've done to make it safe, publicize that internally, make people aware of it, let them know what you've done. You're doing everything you can to make the workplace safe. Talk to individuals about how you can help them and try and act on their concerns. So communications are now more important than ever in employment law. They always are, but they're more important than ever, and more important than ever to document your decisions and the reasons for them. Create a good record of what you do and why you do it, and of the dialogue that you have, so you can then draw upon that later if you're ever challenged. The only other thing I'd say on that point is, as always, be careful about what you actually do document, because what you don't want to do is create something, a document, which you may then subsequently not want to see the light of day. So think carefully about intemperate emails, for example, that you wouldn't want to be sent. So if someone is reluctant to come back to work and you want them to come back to work, we have to look at this in the context of what kind of claims they might bring. That's essentially, as employment lawyers, what we always have to keep an eye on. What are the kind of risks an employer is looking at? What kind of claims might they face if they require someone to come back to work? And let me just go through the prospective claims. They are in relation to, first of all, health and safety, whistleblowing, disability discrimination, unfair dismissal, and indirect discrimination. Insofar as health and safety is concerned, employees have protection against both dismissal as well as being subjected to a detriment on health and safety grounds. This protection applies to employees only, not workers, just employees. And there's no qualifying period of employment. So from day one, an employee is protected against dismissal and detriment on health and safety grounds, and compensation is unlimited. So potentially a very valuable claim. In particular, a dismissal is automatically unfair if the reason, or the main reason, is that in circumstances of danger, which the employee reasonably believes to be serious and imminent, the employee leaves work or refuses to return to work. So in those circumstances, if they are dismissed, then their dismissal is potentially automatically unfair with unlimited compensation. Similarly, if an employee has the right not to be subjected to any detriment by any act or failure to act by the employer done on grounds that the employee left work or refuses to work in circumstances of serious and imminent danger. Now, a detriment can include withholding pay, and it can include disciplinary action short of dismissal. In order to be protected, the employee has to reasonably believe that there's a serious and imminent danger. They don't have to show that that danger exists. It doesn't necessarily have to exist. The employee just has to show that they reasonably believe that there is serious and imminent danger. Now, there's a combination of objectivity and subjectivity in that. Subjectivity in the sense that the employee just has to believe it. If they believe it, then they may be protected. But objectivity in the sense that it has to be a reasonable belief, not just a belief, a reasonable belief. But if an employee reasonably believes that coming to work places them in serious and imminent danger, and if they're dismissed or subjected to a detriment in consequence, then they could potentially have a claim. So what should you do? Well, to kind of go back on what I was saying, talk to the employees, inform them what you're doing to make the workplace safe, try and address their concerns and see whether or not you can reach a middle ground that makes them feel confident about coming back to work. I have to say that claims on health and safety grounds are very rare. They're very rare until now. Let's wait and see what kind of claims we may now see coming out of the woodwork with people coming back to work from furlough leave. Each claim will be considered by the tribunal on a case-by-case basis, and they will take account of the individual employee's individual circumstances. For example, do they have any comorbidity factors which may influence their reasonable belief that they're in serious or imminent danger? Employers are obliged under health and safety legislation to take all reasonable steps to ensure the safety of workers at work. And they may actually find themselves in facing a curious dilemma whereby they've done that. They've taken all reasonable steps to ensure the safety of their workers, but the employee can still have a reasonable belief that they're in serious and imminent danger, if they genuinely believe it and if it's a reasonable belief. So potential for some quite interesting dilemmas to come up. What if the employee believes that their commute to work would place them in serious and imminent danger? Well, there's a decision of the Employment Appeal Tribunal which suggests there's no reason why this protection shouldn't apply to someone on their way to and from work as well as at work. And indeed, the legislation is wide enough to cover that. So if someone says they don't want to come to work because they're worried about catching the virus on their way to and from work, talk to them about alternative means of coming to work, maybe traveling at off-peak times, laying on transport for them, any other practical means you can think about getting them to or from work, and again, document the decision. So these cases are going to be very fact dependent, but be wary of dismissing someone or subjecting them to any detriment where they refuse to come to work because they're worried about contracting the virus. Have a dialogue with them and think carefully about whether or not you may actually potentially be facing a health and safety dismissal or detriment claim if you insist on them coming back to work, or if you penalise them for not doing so. The next potential claim is one of whistleblowing. Like health and safety dismissals, the protection applies only to employees, not workers, and there's no qualifying period of employment, and compensation is unlimited. Protection against detriment applies to workers as well as to employees, however. A dismissal is automatically unfair if the reason, or the main reason, is someone made a protected disclosure. And protected disclosures include information which tends to show danger to the health and safety of any individual. And in order to succeed in a whistleblowing claim, the worker must have a reasonable belief that the information that they've disclosed tends to show danger to the health and safety of any individual, and that reasonable belief must be in the public interest. Disability discrimination. In order to meet the definition of a disabled person, someone doesn't have to be in one of those vulnerable groups which have been identified in the current crisis. Someone can be disabled, and it may not be particularly apparent that they are disabled, but someone can be disabled and meet the definition in the Equality Act to be protected against disability discrimination. And if requiring them to return to work puts them at risk, that potentially exposes the employer to claims of indirect disability discrimination, failure to make reasonable adjustments, and discrimination arising from disability. So if you don't know that someone's disabled, that again underlines the importance of having a dialogue with them, so you can explore with them the reasons why they feel reluctant to come back to work, so you can then identify if they have a potential disability and then respond accordingly. Then there's good old unfair dismissal. It's always with us. Dismissals are automatically unfair unless they're for a potentially fair reason. And here the likely reason for dismissing someone for refusing to come back to work would either be conduct or else a catch-all reason known as some other substantial reason. But on top of that, the employer has to act reasonably in dismissing someone. And what's reasonable or not is going to be different from employer to employer. The smaller the employer, with the more limited the resources, the more likely it is to be reasonable to dismiss someone. So, as is often the case with these kinds of problems, you have to look at the circumstances. The fact that someone is reluctant to come back to work for fear of contracting the virus doesn't necessarily render the dismissal unfair in general, in terms of general principles, but there is a real risk of the dismissal being automatically unfair for health and safety reasons, for the reasons that I was giving earlier. And then indirect sex discrimination, particular issue with female employees who tend to have child caring responsibilities, predominantly over men. And if you insist on a female colleague returning to work and that causes problems with her child caring responsibilities, then that can potentially raise an indirect discrimination claim, potentially. Also, most importantly, reputational issues too. You know, do employers want to be seen to be treating mothers of young children in a way which is unfavorable towards them? It doesn't necessarily reflect at all well on the employer to do that. And then finally, what if someone is vulnerable and insists on coming back to work? So the converse problem. If someone's had enough of being on furlough leave, and for good mental health or other reasons, they want to get themselves back to work. Well, the guidance says quite clearly that those who are clinically vulnerable should be strongly advised to stay at home as much as possible, to keep visits to a minimum and follow social distancing guidance. And those who are extremely vulnerable are deemed to be incapable of work for the purposes of SSP if they can't work from home. It's also a criminal breach of the obligation to ensure the safety of workers at the workplace to have someone at work who is an extremely vulnerable group. So if someone in that group insists on coming back to work, it's more than likely you should be declining their request to come back to work, and quite likely, if they can't work from home, that you should be looking to put them on sick leave. If you have any employee assistance program, refer them to that. If not, there are various websites you can refer them to, which may well provide them with some comfort. And then finally, on this issue, there is a statutory right to be paid when medically suspended, but currently that applies in only very narrow circumstances, and it's unlikely to apply in the current pandemic. So as things presently stand, it's unlikely you would be able to put someone on medical suspension because they're in an extremely vulnerable group, and you may therefore be having to look at putting them on sick leave if they insist on coming back to work, and it would be inappropriate for you to allow them to come back. Thank you, Karen. Are there any questions on that?
Yes, we've had lots of questions on this area, as you might expect. So let's pick up on a few of those. So one question is how much notice you have to give of the end of furlough leave?
Sure. Okay, that's as much mine as Joe's, but I'll happily have a stab at it. Yeah, I mean, have a look at the furlough agreement first of all. That's the starting point. The furlough agreement may or may not specify the period of notice that should be given. Short of that, there is no specified period of notice. I would say, however, that any notice you give should be reasonable. What's reasonable? Lawyer's answer depends on the circumstances, but a reasonable period of notice, absent anything specific in the furlough agreement.
Thank you. And an interesting question on someone with childcare responsibilities. So what do we do if, because they've got childcare responsibilities, they can't arrange childcare and they can't work from home?
Yeah, that's a really good question. It kind of touches on what I was saying towards the end there. Requiring them to return to work may raise issues of indirect sex discrimination. Otherwise, it should be a case of having a dialogue with them to see whether or not you can agree a way forward with them. You may, for example, be able to agree they take a period of paid annual leave. They may take a period of unpaid leave, for example. If you can leave them on furlough or put them on furlough when they haven't been already, that may also be an option. As I say, it's a case of exploring various alternatives. As a generality, subject to this indirect sex discrimination point, you can require someone to come back to work. But there is a real issue around indirect discrimination, in my view, if you insist on someone coming back to work when they are inhibited from doing so because of their childcare responsibilities. So you think seriously and creatively about ways in which you can try to get around that without having to take the kind of nuclear option of insisting that someone comes back, because I do think that exposes an employer to potential indirect sex discrimination claims.
Thank you. Finally, a question in relation to shielding. We have employees who are shielding either for themselves or for members of their family. What do we do in that situation if we want them to come back to work? What are the options?
Okay, well, if the individual is shielding, then that kind of answers itself, if you like. They shouldn't be coming back to work. And indeed, you could potentially be, as an employer, exposing yourself to criminal liability by having them back to work potentially, because you'll be in breach of your Health and Safety at Work Act obligations to provide a safe place of work. If they don't want to come back to work because someone else with whom they live is shielding, then they have much less protection. In terms of disability discrimination, the kinds of protection which I described, namely protection, the obligation to make reasonable adjustments, indirect discrimination, and discrimination arising from disability, do not apply, because the individual themselves wouldn't meet the definition of disability. It's only those with whom they are living who may meet that definition. Potentially a direct discrimination claim, but I think it's very unlikely. Otherwise, it would be the employer is in a much stronger position to be able to require someone to come back to work if they themselves are not shielding. If they themselves are not shielding, then there is a much stronger argument to be able to get them back to work. There may be a potential whistleblowing angle. Potentially, I think that's unlikely to succeed because any protected disclosure would have to be in the public interest, whereas this is going to be specific to that individual's own circumstances and the person with whom they live who is shielding. Otherwise, I think the likelihood is you need to look at the circumstances, but you can probably insist that someone comes back to work. Not great for PR, however, not great for the employer's reputation at all, and think very carefully about whether that's actually the right thing to do in the circumstances, given the individual's own personal circumstances. So you may want to think more creatively about ways around the problem, such as holiday, an agreed paid period of unpaid absence, and so forth.
Okay, thanks very much. Let's move on to the next topic. Can employers impose short-time working or layoff pending a return to full productivity? And that's Joe's section.
Thank you, Karen. Thanks, James. So clearly the 31st of October date for the ending of the furlough scheme is going to really focus minds on the size of the workforce that your organisations can support in the longer term. This is quite a brief run through of these slightly niche options, and James is then going to talk about preparing for possible redundancies, which is clearly where these assessments might take many of you on this call. But if you are hoping to try and retain staff or see through a difficult patch without changing the workforce significantly, short-time working and layoff, slightly traditional phrases meaning basically reduced hours or no hours, are possibly options. These are options that clients looked at when the lockdown type restrictions had started, but before the furlough scheme had been announced. In that, I'm sure we all recall that period of quite a considerable panic as this was all unfolding. Since furlough was in place, it's taken a bit of a back seat, understandably, but now coming more back into the frame. So when I say reduced hours or no hours, if you have a contractual clause allowing you to reduce your employees' hours or lay them off altogether, it's highly likely that that will also make provision for what happens to their pay, because this is the big issue with reducing hours or laying them off altogether. What happens with their pay? Some employers still have those clauses. It wasn't unusual, however, to be chatting to a client about this and no layoff clause, no short-time working clause. Frankly, it's not really been that necessary in many sectors and industries for many years now. First point being, if you have them in your contract, you can use them in accordance with the way they're expressed in your contracts. But I think of more relevance is probably, well, what if you don't have them in your contracts? Because I know that's the case for many people. You can't impose it. If you are imposing it on full pay, whilst that's officially a breach of contract to change something as fundamental as the employee's hours, if you're paying the employee in full, they are very unlikely to complain. You're on a risk-based analysis, you're unlikely to get a claim in those circumstances. The one particular situation I can imagine that being an issue is, for example, where the employee's profession requires them to be present in the workplace, and if they're not, they may, for example, de-skill or have reputational damage. Quite a niche idea, but that's the only situation in which I can imagine sort of enforced paid leave being an issue. So that's a fairly safe approach. So you can reduce hours or put them out of the workplace on paid basis if you wish to. They're unlikely to complain. If you are also imposing the reduction in hours or putting them entirely out of the workplace and reducing or getting rid of pay altogether, then clearly the employee isn't going to like that. There's going to be a great risk of claims coming. So just as an aside there, when I mention if you haven't got it in the contract, also check your furlough letter. You may well have added these clauses in at the point of furloughing staff. So you might not have had short-time working or layoff clauses before, but you might have had them since fairly recently. Those you can then use. So if you haven't got those, but you impose it anyway, you're vulnerable to claims. And that would include constructive dismissal if they have the requisite service, unlawful deduction of wages, breach of contract. It's not a path you would want to go down. It will be messy. They're not going to like it. So what you do, if you want to reduce hours or take them out of the workplace and reduce pay, probably proportionately, but perhaps not. Clients are being quite creative in various ways of proposing this to their staffing groups, is you need the agreement of the employee. If you want to change pay and hours and they agree to it, you're in a good place. That's sort of the beginning of the end, as it were. To get to that place, as I'm sure you'll all appreciate, discussion helps. Consultation, if you have a unionised workforce or you have a sort of standing committee that you consult with in your employee group, then that's what you'll need to do. If not, usual consultation, keeping people informed, explaining the background to your need to make these changes and seek their agreement, which you need to capture in writing. Clearly, given the economic environment, you may well obtain their agreement because they might think, well, if this keeps the company going, keeps my job, that's what I want. So I'm all for supporting that. If they fail to agree and your next option is job losses, then you will want to consider collective consultation requirements. And James will touch on that later on. But if there's a potential of 20 or more employees at one site being made redundant, if you can't get the agreement to the redundancy avoidance measures you were hoping to achieve, then you might need to do all of the consultation on those pay and hours reduction measures by way of collective consultation, so that you are then ready to, unfortunately, start making terminations if they don't agree and you can't solve the issues you were trying to solve through those alternative measures. One final point to make on this would be something that's come up. I do a bit of advice for individuals from time to time, and I have a client at the moment who was told to sign a document confirming a reduction in hours and pay, and was told that he personally would be made redundant if he didn't, and wasn't given the impression that that was a choice or there could be any discussion. And we are looking at saying that that was signed under duress. So he's since taken advice and is assessing his position, and that there is the risk then that that invalidates his agreement to those changes. So it's really important to take the consultative approach to avoid an employee later being able to deny the validity of them agreeing to it in the first place. So make sure they understand the changes you're proposing, consult, keep them fully informed, and don't shy away from expressing somewhere in the written document that they are indicating their consent or their agreement, because that is what they're doing, and it's important that they appreciate that, as well as signing on the dotted line to confirm it. That's all I was going to run through on those types of bringing in those kinds of changes. Karen, are there any questions on that at all?
We have got one question, but I'm keen to make sure that we have enough time to cover redundancies properly.
Sure.
So let's move on to James now to look at the steps employers need to start taking to prepare for possible redundancies in the future. And we can come back to that at the end if there's time. So James, thank you.
Yeah, thanks, Karen. On the topic of redundancies, first point I would make is to remember that reputations are forged in a crisis. And what you do now as employers is going to be remembered in the future, and remembered importantly by those who remain. So it's absolutely crucial that you get the redundancy process right if that's what you're faced with having to do. So be open and honest with people as to the reasons for redundancies. Bear in mind what's been said to people previously, in particular what's been said to them when you had to put them on furlough leave, and try not to say anything that's inconsistent with what's been said before. You don't want to lose the trust of employees. Be clear in what you say and give yourself plenty of time. It's going to take longer nowadays to effect any redundancies than it has done in the past. Don't rush the process if you can help it. Make sure you give yourself enough time to implement it. One of the, inverted commas is the wrong word, but benefits, one of the benefits of a redundancy process is you can control that process. So make sure you have a proper project plan in place and you've given yourself time to implement it before you have to press the button. So let's look then first of all at collective redundancies. This is where you have 20 or more redundancies at one establishment within a period of 90 days or less. And in those circumstances, there is an obligation on the employer to consult with and to provide information to appropriate employee representatives. If you know now, at this moment, that you're going to be looking at having to make 20 or more redundancies in the future at one workplace, at one establishment, then the obligation to inform and consult has kicked in. You need to be taking steps now to start informing and consulting with employee representatives, such as the obligation under the legislation. In any event, the obligation must be begun, the consultations and information must be begun in good time, and at least 30 days if you're looking at 20 to 99 redundancies, or 45 days before the first proposed redundancy if you're looking at 100 plus redundancies. So 20 to 99 redundancies, at least 30 days, 100 plus redundancies, 45 days before the first redundancy takes effect. The clock begins to tick when you hand over the Form HR1 to the employee representatives and when you provide them with the information in writing that the legislation requires you to deliver. So that's when the clock begins to tick. If you don't have recognised unions, you'll need to arrange for the election of employee representatives. You may need to think about training them. If they've had no experience of this kind of thing before, it can only reflect well on you if you have them trained. External advisors, such as ACAS, for example, but other organisations, we indeed also provide training for employee representatives. Helps particularly so they understand what consultations actually involve. Sometimes it's assumed that consultations are negotiations or even agreement. That's not right. Consultations are something quite different. The legislation requires consultations to be carried out with a view to reaching agreement. There's no obligation, but a view to reaching agreement about ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of the dismissal. And the duty also requires an obligation to consult about the business reasons for making redundancies. So you have to consult with employee representatives about your business justification, consult at a collective level. If you don't have time to consult or to consult properly, there is a potential defence called a special circumstances defence. This applies where circumstances render it not reasonably practicable to consult in good time. In those circumstances, however, you still have to take such steps as are reasonably practicable. You still have to do your best to try and consult. Special circumstances are very narrowly interpreted. For example, it doesn't include insolvency, and also the circumstances must be special. On top of that, not only must the circumstances be special, probably you would think a pandemic is, but those circumstances must mean that it's not reasonably practicable to comply. So we may be facing a pandemic, but it doesn't mean to say you can't necessarily comply with the obligation to inform and consult. So the pandemic isn't an excuse for not trying to comply with that obligation. What if you don't do it, or what if you get it wrong? Well, the penalty is a protective award, which is a financial award of the Employment Tribunal, and that's of up to 90 days gross actual pay for each employee who's been affected. So potentially a lot of money. And the way the tribunal assesses that award is they start at the top and then see if there's any reasons to reduce the award to something below 90 days. So if you've gone some way to trying to comply with your collective information and consultation obligations, then that may mean that any award is reduced. But if you haven't done anything, you may be facing a very substantial financial penalty. On top of that, failure to inform and consult with appropriate employee representatives may also undermine the fairness of an individual dismissal as well. So an extra potential sanction if you don't comply with that obligation. So I have a poll now to put out to our delegates. If you are considering making redundancies, how many are you likely to make if you are considering them? Less than 20, 20 or 99, or 100 plus? I hesitate to say this, but I can see on the horizon, and certainly from feedback which I've been getting from clients, I suspect that my colleagues and I are going to have fairly full inboxes over the next few weeks and months with advising on redundancies, unfortunately. So that's not the kind of work which one necessarily particularly enjoys having to do, but it's a fact of life, unfortunately, at the moment. So the results show that people who are looking at making 100 plus redundancies, 4 out of 64 responses, 20 to 99, 16, and then fewer than 20, 37 out of 64 responses. So the majority is certainly looking at fewer than 20, so that's encouraging. Redundancies, obviously bad news, but it's encouraging that hopefully people aren't looking at redundancies on too large a scale. So then in terms of individual redundancies, you have to follow a fair procedure. The nature of that procedure really depends on the circumstances. It is likely to include things like choosing an appropriate pool for selection, devising fair selection criteria, and those criteria should be as objective as possible. Apply those criteria in a way that's fair, and keep records to demonstrate how you've applied them and to show that you've applied them in a way that's fair. Consult with anyone at risk of redundancy before making the decision to terminate their employment. That's obviously crucial. Consider alternative employment. Are there any other roles you can offer them as an alternative to redundancy? Confirm the decision in writing and give the individual a right of appeal. A question that often arises is, can you make a furloughed employee redundant? Well, the answer to that is yes, you can. The fact that someone's on furlough leave does not mean that they are immune from redundancy. It's indeed clear from the guidance that that's something which is permissible. You do, however, have to consider alternatives to redundancy as part of a fair procedure, and it may be that furlough might be an alternative that you should consider, but that really depends on your size and resources, and obviously the financial consequences of keeping someone on furlough leave rather than making them redundant. There's logistical difficulties associated with it, I appreciate, but those difficulties are not an impediment or a prohibition against making redundancies. Whoever's conducting the redundancy exercise, whichever manager is involved in that, is likely to be providing a service to their employer. So if they are on furlough leave, being engaged in a redundancy exercise is likely to break that furlough leave That's at least in terms of representing the employer. Someone who's being consulted, someone who's at risk of redundancy, it probably wouldn't break their furlough leave. But someone who's conducting the redundancy exercise, it probably would. Redundancy pay. Can you use the government grant under the coronavirus job retention scheme to help fund redundancy pay? The answer to that is no. It's clear that the grant doesn't cover either statutory or enhanced redundancy pay. But our view, you can, however, use it to fund notice pay. So while someone's been given notice of dismissal by reason of redundancy and is serving their notice, not literally, they're not working, but while they're serving their notice on furlough leave, you can use the grant to help fund their salary costs while they're serving out their notice period. Not, however, if you make a payment in lieu of notice, known in shorthand as a pile-on. If you make a pile-on payment rather than requiring someone to serve their notice, then you can't use the grant. And that's not least because you make a pile-on because someone's employment has terminated. And once their employment's terminated, then the grant is no longer available. So if you want to be able to use the grant to help fund notice pay while someone's serving notice, they have to actually be allowed to serve their notice and not work rather than make a pile-on payment. So what about logistics? There are no hard and fast rules as to how you actually go through a redundancy consultation exercise in the current environment. You have to be practical. But provided you do as an employer, provided what you do as an employer falls within what's called the band of reasonable responses, then that should be okay. The band of reasonable responses is a shorthand way for saying that provided what you do is what a reasonable employer would do, if a reasonable employer acting reasonably would do what you do, then that's fine, and that would be a fair procedure. So it may mean consulting over Zoom, for example, or a similar facility. It may mean arranging for consultation meetings to take place by that medium. It may mean arranging the election of employee representatives by virtual means rather than using the traditional pen and paper method, etc. So it's just a question of being practically minded about how you go about it. So Karen, thank you. That's all I had on redundancy. Have we got any questions on that, please?
Yes, we've got lots of questions. Okay. I'm just keeping an eye on to pick up one on redundancy, and then we'll turn to some of the others that have come in as well. So on redundancy, do we need to complete an HR1 form if we're planning to make less than 20 people redundant?
That's a good question, and the answer is no, you don't need to complete an HR1 form. And indeed, it's 20 or fewer people at one establishment. So you may be making 20 or more, but if you're making fewer than 20 at each establishment, then you don't need to do an HR1.
Thanks very much. So turning now to some of the other questions that have come in during the session, and thank you very much for all of your questions. We've had dozens and dozens of them, and unfortunately we can't answer all of them, but a question for Joe in relation to layoff. Can an employer change terms and conditions to include layoff if there's no clause in the contract at the moment?
Yes, absolutely. The golden ticket there is the employee's agreement to it. So any fundamental change of the contract, which that would need their agreement.
Thank you. And a Cheapy question for James. Where there was a Cheapy transfer at the beginning of June and employees who transferred in had already been furloughed, can the new employer put them on furlough with immediate effect and claim the grant for them?
There we go. I thought I'd managed to get it right all the way through. I had myself on mute. Yes, originally that wasn't clear from the guidance, and it was one of the many questions that was raised of the government as the furlough scheme progressed, and it's now clear that if someone Cheapy transfers in, then they can be put on furlough leave. Thanks
very much. So I'll wrap things up now. Thank you very much to everyone for joining us today. We've had a fantastic response to this webinar, and I'm really pleased that so many of you were able to join us. I hope that you have found it useful. We're going to circulate a copy of the recording very soon, and we're also putting together an article on the changes to the furlough scheme that were announced on Friday. So we'll send you a link to that as well. We're planning a series of employment law webinars at the moment, together with a whole range of content, which you'll start to see over the next few weeks. So please do look out for that. And we hope that you're able to join us at our next webinar. When you hang up, you will be invited to complete a short feedback questionnaire. If you could do that for us, it would be really helpful because it helps in terms of planning future events. So once more, thank you to our speakers. Thank you for joining us today, and hope to see you soon. Goodbye.
Thanks, everyone. Thanks, Karen. Goodbye.
Thanks, Karen. Bye-bye.